let's look at disability and the employee. We want to make certain that in the process that we're developing a good, solid employer defense against any claims about disability discrimination. When you have the interactive process with the employee, make certain you document that, make certain that you're paying attention to all the details, your job descriptions are current, make certain that you have the person show you the workplace about the accommodations you're talking about, if that's the case, or you actually go look at it, and you keep careful track of what you said. Those are always the best defenses you can have. Is there a legal non-discriminatory reason that the employer is going to be taking an action other than the disability discrimination? Is it over here, I need to lay you off because we have a layoff coming, they have a budget cut, and lo and behold, the only person who's laid off out of a department of 15 people is the one that has a disability? You know what? That looks pretty suspicious. But if 5 people are laid off and that person is the lowest, one of the 5 lowest with longevity in the organization, then now all of a sudden you have an LNDR on top of that. So pay attention. Make certain that you're providing the same type of notices to the person with the disability as not, or if it's possible to make an accommodation, fine. But if it's impossible or if it's unduly burdensome, which we already talked about, that is a legitimate defense. Atkins versus Salazar. We had somebody file a case over the fact that they had uncontrolled diabetes and they were terminated according to the employer. They felt it was inappropriate. They felt it was based upon race and discrimination. They filed and the court upheld the employer based upon the uncontrolled diabetes issue, which is why they terminated them. They felt there was no way to make an accommodation. So now you have a case where somebody filed saying, disparate impact, you picked on me because of my race. That is always a possibility. So make certain that you're documenting things, being consistent, making certain your notices are fine. Make certain when people talk to each other that, especially as the employer, you're taking the emotion out of it and focusing in on the facts. Looking at this from a practitioner's viewpoint, you need to always make certain that you have in the back of your head 2/3 of all lawsuits between the employee and the employer, between the two of them, are based as to how that employee was released. You can always focus in as to these are the facts as I see them. Okay, what is your perspective on the facts? Listen and then make an evaluation, but it should be a non-emotional one. It should be a business-oriented evaluation as to what's going on and then respond appropriately. If you looked at accommodations, make certain you're paying attention to the fact that over here we tried to do this, it wasn't doable because it would actually change the fundamental nature of the job. Make sure you can document that. Sometimes you have different aspects of people that have a significant intellectual impairment. The official definition of an IQ is between 70 and 75. I had one of these situations where we actually had a building once upon a time when I worked in the K-12 district. And so I would go over there about once every 2 weeks just to check up on things. And they employed between 30 to 40 different people that would fit intellectual impairment. And they did simplistic jobs in the aspect of actually doing something. I have to tell you, the fact that the people in the building had a job, they would be picked up in the morning, they felt important, they felt dignified, they felt being treated with respect. It was really kind of an awesome thing to see that happening. Otherwise, they would be sitting in a home environment, and that would pretty much, they would be depressed all day long. And in the meantime, also, it would take other people to take care of them. It was a wonderful opportunity. If you have a chance to bring in one of these people and they can actually do the work, it's a wonderful opportunity for you as a potential employer. But regardless, they have to be able to do the job. If the limitations are so much they can't do the job, do not hire them, because you may put them in a situation that is frustrating and maybe even physically dangerous because they don't understand what's going on around them. And the psychological impairments now, it seems to be growing to the point that 1 in 5 U.S. adults have some types of mental health services in any given year. Even college professors can have that as well. So when you start looking at 1 in 5, that's a lot. Of this group, 1 in 25 have some type of serious mental illness that interferes with one or more life major function. You already know as soon as you start interfering with a life major function, it moves up the scale to become a true disability. What are you doing to sit down and take care of that? Here is a shopping list. The shopping list of different types of mental emotional impairments: depression, bipolar disorder, anxiety disorder, post-traumatic stress disorder. It's not always about warfare, by the way, when we talk about that. Okay, substance abuse disorders, psychotic disorders. Pay attention to the list. Sometimes you will never know that somebody may have that because they may be on a medication and they're consistently taking it. One time we had a top administrator at one of our colleges. He had one of these aspects over there. We didn't know about it until he went off his meds, and then all of a sudden now we had a serious problem. We got him back and life was good again. Sometimes you don't know in regards to that because of the fact that they do a good job of keeping things under control. But when they don't, pay attention to what's going on and still treat them with dignity and respect and find out what the problem is and do your best to try to sit down there and resolve that. But sometimes it's a disability and they should notify you, and that may come underneath ADA, and you need to make an accommodation if possible, if they can actually still do the substance part of the job. So, employee hostility, if somebody has an issue, there is really, it's a matter of people can't exclude you socially because of that. We've all seen that type of behavior in life, and it isn't very pleasant. But sometimes it depends upon, are they picking on the person because of the discrimination? Are they picking on them because of this? Are they excluding them? Pay attention to that in the workplace and watch out what's out there in the process as well, because you don't want to have people feeling that they're bullied in work. Everybody, even people that have a disability, have a right to come into work and not feel that they're the center of attention all the time because of the fact of gossip and hearsay. There is a lot of this, the lower courts don't have a solid hostile work environment for people that have disabilities. They're making decisions on their own. They don't have a measure from the Supreme Court to go by. So you'll see who's protected by the ADA. Make certain that you have different aspects of it. You don't want to be that test case that hits the Supreme Court someday. Epilepsy. There's a case here. Somebody took an indelicate photo of somebody when they're being restrained during the seizure. If you ever have had somebody with a grand mal seizure in the workplace and they're thrashing about, it is a very difficult circumstance to have for the employee, although they may not be fully aware, but a lot of times they are fully aware, but also the employees around them. If somebody has an extreme case, ideally the supervisor should know about it and should know how to treat the situation just in case it happens. So watch out with this aspect over here. In this case, the photo itself wasn't proof of coworker harassment intent, but still it probably didn't belong in social media in the process as well. Employers, and we really have a tool called workers' compensation. Workers' compensation provided an opportunity to reduce or almost eliminate the case of an employee that's injured at work to sit down and sue the employer. There actually is an entire workers' compensation court system in every state that deals with this issue, and there's actually a schedule for different damages. There actually is a schedule, believe it or not, for your little pinky. If you have your right hand little pinky and you have it chopped off at work, I'm not exaggerating, okay, there's a price for that. If you're right-handed, it might be more than your left-handed pinky. So it just depends, which pinky that you have. But the reality is, if it comes out of the course of employment, there's a workers' compensation system that really is over there to sit down and provide some relief to the employer. So we look at workers' compensation. It gives up the right to sue by the employee on the employer, but it doesn't give up the right to sue for other things that may happen that may be out there as well. Let's say if a third party. So the genetic testing also, we've eliminated this with GINA, the Genetic Information Non-Discrimination Act, okay, but it applies to people at 15 or more. Technically, if you have less employees, you can actually have somebody's background checked and take that for employment action either way, but be careful on that because there's state laws that are also involved with that. FMLA, the Family Medical Leave Act, okay, and the ADA, they work kind of hand in hand. Usually the FMLA is for family medical issues. The bulk of the times that I've seen it used, it really is about pregnancy. You have that applied. You also have things like in California, we have a similar act of that actually provides for paid leave as well. Sometimes you have to articulate the benefits and the timelines and track them both at the same time. ADA, it doesn't have a specific duration. FMLA is a federal law and it's 12 weeks of leave per year. So here are the bullet points about the disability in the employer. The burden to prove discrimination is with the employee. The employer should know about undue hardship to the employer, making certain that the employee to try to make the accommodation is not extremely expensive or changes the work environment or changes the job. There are a group of people out there that is actually pretty substantial on a national basis that have intellectual disabilities. You have an opportunity there to maybe sit down and bring somebody in, if that's possible, that can handle routine work and actually work in the process. But we're having more and more mental disorders, and pay attention to the physicality of the job. Also issues like epilepsy, which are not seen, but when they arise, can cause great havoc. Disability and the employer, pay attention to it. This is a critical aspect as to how you handle it. Keep in mind, 2/3 of all lawsuits between employee and employers deal with how people are released. Take care.